All right, let's continue the conversation with Mpumelelo Zikalala, legal practitioner at Zikalala Attorneys. A very good evening to you, and thank you so much for speaking to us. Picking up from that point that was made by the EFF's legal counsel, saying that our electoral system in itself lends itself to abuse by the majority because it uses that to pick and choose whom to punish, thereby protecting its members but punishing the opposition. In your view, the case that they presented, is it true? Is our parliamentary system amenable, or should I say vulnerable, to this kind of manipulation?
Good evening to you, good evening to our viewers. I would seem to concur with him. Yes, it is. And it also depends on the majority of the individuals that are there with that particular political party. So the more dominant the political party is, the more easier for them to bend the rules in order to suit them. Remember that when you come into parliament, that's when you dictate the rules of how things are going to be and how things are going to be run. And you do not know every eventuality which is going to follow at the end or down the line as to how that you should be able to deal with it. But it should come back to the basic principles of fairness, the one of saying that whenever something is being adjudicated or a decision has been taken, whether it's correct or not, you need to have a fair and unbiased decision maker who's going to be there and be able to determine whether that particular conduct has been done correctly or not. So in this case, it is one of those unfortunate events that says once the majority has ruled and once the majority has decided, unfortunately, that's how things are going to be. And there's basically nothing that you can do about it except go to the courts. And maybe the courts will be able to hear you.
I'm just wondering, why would this not anticipated given our constitution? And I know this is an argument that the EFF also makes, saying that, for instance, Parliament's ability to discipline, that's not what they're questioning, but rather the application thereof. The rationality and the outcomes, is that the problem, or the manner in which the rules and regulations are being interpreted?
It's actually both manner of interpretation, but most importantly, the execution of those particular rules that will be in line with the principles of natural justice. What are those? The one that says, if you are going to try and be able to test whether my conduct is correct or not, allow me to present my case, which is one, the right to be heard. Then secondly, I must be heard by someone who I also believe is going to be an independent, unbiased individual who is going to issue out those rules in a proper manner. And then lastly, which is mostly a technical term or a technical point that is mostly forgotten, use all the elements and the points in time in order to allow me or not to be used for ulterior motives, for example. Here's a question. Why didn't the Parliament engage in these processes maybe in June or earlier then? Why didn't they come and conclude those particular processes maybe at the end of the year? And instead of choosing February, which is the month in which Parliament opens and there's a State of the Nation's address, choose March, for example, or June. So what's the rationale or the significance or the science behind choosing the type of sanction that has been issued? What is it that you are trying to prevent? What is it that you are trying to teach other parliamentarians, to say to them, if you engage in this type of conduct, this is what's going to happen? That's where the abuse comes in terms of saying, even though the rules may be noble, but the implementation of the rules at the end of the day do not fit the purpose in which the rules were intended to serve.
So when we were designing the Constitution, because the EFF also raises the issue of the statutory design. So if we're dealing with Parliament, our PR system, so participation versus representation and how you affect some of these rules, would this not have been thought out? And I'm just wondering, is there a mismatch in the design between Section 12, subsection 3A of the Powers, Privileges and Immunities Act and the Constitution, particularly sections 1, C and D? Are they inconsistent?
We have to realize that when the Constitution was created, they couldn't find a one-size-fits-all situation which is going to exist up until the end of time. So, which is why there are provisions for certain amendments to be done, which is why there are provisions to say, whenever we're starting a new parliamentary season, you must be able to sit down within the various committees that we're in, design the rules which are meant to abide or that we need to abide to. The reason why we do that, things change as we move along. We get new challenges, new problems that you might find. new things that we need to deal with, because in the parliamentary system and the rules that existed in 1994, for example, they are very different to what Parliament is today. There are many other things that we need to take into account, especially when it comes to the robustness of Parliament, when it comes to the manner in which questions ought to be asked and the type of confrontations that might be there. Some may view it as ill-discipline, some may view it as people who are very passionate about asking questions in a manner that is direct and maybe a bit louder than any other individual that might have. So when you need to develop that type of particular process, or maybe that's why there was this space which was opened in Parliament to say, whenever you are starting, let's call it a new season of Parliament. Let's make sure that we're able to create the rules which are going to be accommodating. Now, if ever there are conflicts, then you run back to the system which was created before, not taking into account, or the system that entrusted that those that use the system are going to develop and be able to make it user-friendly. That's where you find the loopholes, because whenever things such as these ones have taken place, they then run back to the rule book and throw the rule book at you and says, the rule stage 1, 2, 3, 4, 5, this is how things are going to be followed. If you misbehave, this is how we are going to discipline you. And all the loopholes that are there are not being taken into account. And that's why you find some decisions which are adverse and some which will not favor certain political parties, especially small political parties.
All right, Mr. Zikalala, quick and final question. The ruling, was it based on technicality, or as per Parliament's lawyers' claims that it was because the EFF imposed unreasonable timeframes?
It was based on a technicality, that of agency. Remember, if you go to court on an agent basis, there are two legs in which your matters are assessed on. Firstly, is the element of agency. If you fail on that, they don't even look at the merits. They say, come back on another day when you've given enough time for all individuals to be able to take into account whatever problems or complaints that you might have. So in this case, it was a classic case of saying that there's no agency on a technical basis, maybe on the merits. If you hear the matter down the line, maybe in March or in April, when the proper time frames have been allocated and individuals have been given enough time to file in their affidavits, the EFF might come back victorious in terms of saying the adjudication process that has taken place or the procedure which was not followed is not one which is fair, and everything must be done afresh from scratch. However, they would have missed this particular opportunity of being able to serve and sit in that sauna and be able to debate in whatever manner that they want to debate. But there's still room in terms of saying it's not all the members of the EFF that are apart from standing Parliament. So they still have some representation in the Parliament to deal or to discharge their constitutional duties.
Thank you very much for your time. Mpumelelo Zikalala, legal practitioner at Zikalala Attorneys.